Swayam Prabha. Digital India. Educated India.
Friends, moving on to the last part of fundamental rights under the Constitution of India, we have to discuss two articles. We have discussed so far with Article 30. There is Article 31 of the Constitution of India and then Article 32 of the Constitution. Now, you will notice that Article 31 of the Constitution is also a very critically important article. However, this article now stands, removed from the Constitution, though not entirely, but in its larger context. Article 31 actually did state, as it was adopted in the Constitution, it stated right to property as being one of the fundamental rights. Unfortunately, in an amendment, which is the 44th Amendment Act of 1978, this was taken off and it was put in Article 300 of the Constitution. And that is how right to property no longer is a fundamental right. However, it is a right under the Constitution, and that is how you will notice that it has been treated. We have Article 31A. Again, you will notice that it talks about the acquisition of any estate. That is provided under Article 31A. Most of the land reform legislations did look at acquisition of estates. It did take over a lot of entities and corporations. We know that in the 1970s and 80s, while we were influenced by the socialism theory of governance or democracy, we did look at nationalization of banks and public sector undertakings being established. Government took over the duty of doing a lot of businesses, extraction of minerals, running of trains and buses, so on and so forth. So I think that is also something that is a good discussion under the Constitution of India about the duty of the state vis-a-vis what it wanted to do with private property in terms of acquisition. And also, I think very importantly, there were these jagirs that were there in the princely states. And hence, those jagirs could definitely be taken by the government, and only the state could actually own some kind of estates. That was definitely provided for in the Constitution. We move on to Article 32, which is the most critical part of the Constitution. And we know that constitutional remedies are the core and important aspect of the fundamental rights chapter itself. Now, Dr. Ambedkar had clearly stated that this article, that is Article 32, is the very heart and soul of this document called the Constitution of India. It is really very important for citizens to have constitutional remedies, without which rights that are guaranteed under Part 3 of the Constitution will only remain rights. They will not remain fundamental. They may remain legal, but they will not remain fundamental. So, without Article 32 and Article 226, which are called the writ remedies of the court, these rights that we have spoken so far would not be fundamental. They will not be core. So, he emphasized upon this. He said this is the most important article, and he said that fundamental rights would be of no use unless a proper mechanism was developed for citizens to avail these rights and enjoy them in a real meaningful manner. And also, if they are not able to exercise any kind of remedies, then it would be really of no use. Now, Article 32, as it says, friends, the right to move to the Supreme Court. by appropriate proceedings for the enforcement of your rights. So we have the hierarchy of the court system in India. We have a judiciary that starts from, say, the district level. Within the district level, you have criminal and civil courts. You ought to be an aggrieved individual. That is what is the principle of locus standi, to go to the court and claim your appropriate remedy, either against state or against private individuals as well. Uh, of course, from the district court, you are supposed to look at an appellate kind of a jurisdiction to the High Court. From the High Court, you can appeal to the Supreme Court. Now, you will notice that in certain cases, appeal is a discretion of the court. The court may grant you or admit your appeal or may not admit your appeal. But in most cases, like for example, in case of an accused having been given death penalty, then the appeal is kind of a right, so that the constitutional court or the apex court can actually decide whether it was appropriately granted or it was not. However, you will notice that from the High Court you can go as an appeal to the Supreme Court. From the Supreme Court you can take a review within the Supreme Court, from a 2-judge bench to a 3-judge bench, and then the mercy petition, as it were, if in case death penalty is being awarded, goes to the President of India. However, under Article 32, the point that one realizes is that you don't have to go under the rigor of district, High Court, Supreme Court, and any other court or any other review in the Supreme Court. You have the right to go to the Supreme Court directly. So you cut short this time and the rigor and process that is established by the judiciary, and you go to the Supreme Court directly in case you think there has been a breach of your fundamental rights by the state or by any other authority. Now, this any other authority is something that you can refer to our discussion under Article 12 of the Constitution. So you will notice that courts have generally two broad jurisdictions. One is called the appellate jurisdiction. So when I said from district to high court to Supreme Court, it's usually an appeal process. So the Supreme Court is then considered as an appellate court. But when you're approaching to the court directly, then you are going under what we call as the original jurisdiction. Now, Article 32 is an original jurisdiction suit, right? So wherever a citizen feels that his or her fundamental rights are going to be, infringed, violated, or he finds that the machinery to exercise his right is not very effective, then he can definitely approach to the Supreme Court under Article 30. So this is a right to move to the court and seek the enforcement of your rights. And the Supreme Court has power under Article 32 to issue directions or order or any kind of writ for the enforcement of any fundamental rights. And the writs that are generally issued under Article 32 include, please note, the writ of habeas corpus, mandamus, prohibitio, certiorari, and quo warranto. The writ of habeas corpus, as many of you would know, it is usually used to get a person who is in detention. Habeas and corpus means produce the person before the court of law so that his rights can be determined, either in detention or in custody or vis-a-vis state exercise and abuse of power. So that is what the writ of habeas corpus is, and this is generally being used vis-a-vis police action of the state. And you will notice that generally law is created by the legislature, but it's the executive that implements the law. And in its implementation, the executive may actually violate the principles of natural justice, may violate the principles of protection of fundamental rights, and hence the courts will intervene in the grant of the writ of habeas corpus. Habeas corpus in current times has been utilized even for producing a person who is actually missing or who has gone missing, and requesting the state to actually take actions to find the missing person. This is something that has also been brought about through the writ of habeas corpus. So any person in the eyes of law can seek the intervention of the court, Supreme Court, under Article 32 for the protection and for the preservation of his fundamental right. And he can ask the court to protect his interest by issuing these kinds of writ. So is Article 32 a fundamental right itself? The answer is yes. So it is one fundamental right being used for enforcement of all other fundamental rights through the help of the court. Interestingly, if you see, the power of the Supreme Court and the power of the High Court are two distinct powers, because this is under 32, the other is under 226. The wordings are almost the same because the writs that the courts of High Court and Supreme Court issue are one and the same. But when can you go to the High Court and when can you go to the Supreme Court? I think this is probably left to the individual choices, because Article 226 can also be utilized in case there is a violation of fundamental rights. However, Article 226 is a little bit broader and wider, because under 226, apart from fundamental rights, you can actually go into the Supreme High Court, for the enforcement of a legal right also. So fundamental plus legal, Article 226. If it's just fundamental, it is Article 32. Yeah. Now, considering the fact that there are other kinds of writs like the writ of mandamus. Now, you will notice that the writ of mandamus is like a judicial review of executive action. If this writ is being issued, then an executive officer in the government will be expected to do his statutory duties, which means that either he has omitted to do it, or he has done it in an act that infringes the rights of citizens, or he is unable to perform his duty so as to protect the rights of citizens. In those circumstances, with the power of judicial review, the Supreme Court will definitely intervene and issue the writ of mandamus, directing that government executive officer to do precisely and exactly what is supposed to do by the court order. So that is what the writ of mandamus is. It's a very powerful writ, and it is used to protect citizens' interest vis-a-vis the state. Right. So the state and its functionaries ought to, facilitate the rights of citizens, and if they fail to do so, the writ of mandamus is a very powerful writ that is used quite very often. Writ of prohibition and certiorari. These are two writs which actually look at judicial review of the judiciary itself. So these two writs are generally issued when there is a provision of a higher court trying to supervise a lower court. So prohibition literally means to forbid. The writ of prohibition means to forbid. That means the higher court will ask a lower court that, look, you are exceeding your jurisdiction. Please do not do so. This is not a case within your jurisdiction. You can either transfer the case to some other court, or you can transfer the case to the high court. That is what. So it may prohibit a lower court from admitting a matter or deciding a case in case the higher court thinks that the lower court is out of jurisdiction. That is what prohibition means. The writ of certiorari means the term certiorari is a Latin expression like prohibition. It literally means to be informed. This writ is generally issued against a judicial or a quasi-judicial body to either transfer the case or quash the case as the issue is. Generally, certiorari means that the higher court comes to the conclusion that a judicial or a quasi-judicial body is not deciding the case appropriately, and hence they would want to exercise judicial review on this particular case. So that is when the writ of certiorari is usually issued. The final writ is called the writ of quo warranto. Quo warranto means under what authority or under what warrant. This writ is usually issued to challenge the occupation of any public office. So if any person is appointed to any public office, he or she must be able to justify the qualifications and the requirements to hold that kind of public office. So to check irregular, illegal appointments to public offices, this writ is generally being issued. So if you see all these 5 writs that are there under 32 and 226, literally make judicial review a very powerful tool in public administration. So public administration cannot have its discretion in a manner that violates the fundamental rights of citizens. The judiciary will check public administration. It will balance between the right of public administration to the right of citizens, and it will ensure that public administration is done in an equitable manner, in a manner that does not violate the rights of citizens. So, um, of course, when we talk about the Supreme Court under Article 32, some authors have very rightly said that the Supreme Court under Article 32 has been the defender and guarantor of fundamental rights of the citizen. Uh, and remember, Article 32, though is original, it is very wide in its power. And how and when the Supreme Court can intervene, uh, is it only on just some rare cases that the Supreme Court can come in? No, the Supreme Court can exercise 32 as and when it feels that it is very, very expeditious for the court to intervene. It is effective for the court to intervene. It may want the remedies to be inexpensive, speedier, and more, probably in some cases a summary remedy. So I think the Supreme Courts can definitely try to intervene in these matters. Now, has the Supreme Court just intervened under Article 32 for fundamental rights, or also have they, extended for any statutory or legal right? You will notice that because right to life under Article 21 has been so broadened, so expanded to mean so many different facets. So you will notice that Article 32 has been invoked not only for what is being stated in the Constitution, but what the Constitution actually means for a citizen to have a dignified life in the country. So for all those, unenumerated, unlisted, if you want to call it, as explained, maybe those rights that have come from judicial precedent, Article 32 has been invoked. Um, Please note, while writs can be invoked and writs can be sought by the court, uh, Article 32 does not stop the Supreme Court just in terms of giving writs. It can also give directions. It can also pass orders, as the case may be. One thing that we all should understand is the the right under Article 32 is not something that you need to postpone. Uh, so the courts have said that even if there is an alternate remedy, if your fundamental right is violated, approaching to the Supreme Court under 32 is still available, right? So having an alternate remedy is no bar to seeking the relief under Article 32. Right? So the Supreme Court is your protector, Supreme Court is your defender, and an aggrieved individual has an option to either go to the High Court or to the Supreme Court or any other remedy that he has. So the jurisdiction of the Supreme Court on the 32 can always be invoked. Now, one should also know that there is something called doctrine of laches, LACHES. Now, doctrine of laches very clearly means that there has been a delay in seeking remedy. Now, the courts usually invoke this doctrine even under Article 32 and 226. So you can't unnecessarily delay approaching for remedies. Of course, if you are someone who could not access justice, someone who is not literate, then probably the court may, under the doctrine of laches, give you an exception. But generally, an unexplained delay may actually take away your right to seek remedy under Article 32. For example, in the Sardar Sarovar project, the Narmada Bachao Andolan versus Union of India, AAR 2000 Supreme Court. In this case, the petitioners who had very appropriate intention to look at the rights of tribals or forest dwellers who were not compensated when the Sardar Sarovar and the Narmada Valley project was being planned, and who were displaced and the government did not actually intervene in the case. One of the pleas in the Narmada Bachao Andolan case was that the dam building must stop and the dam heightening project must not be allowed to continue. Now, in this case, I think the court did say that the petitioners approached pretty late, and opposing the construction of a dam at a very late stage when so much of public money or taxpayers' money has been already involved, and there is a public interest. The public interest is that this is going to give drinking water to a large section of the community in Gujarat. Uh, this petition should be barred by limitation or by the doctrine of laches. So the courts have warned civil society organizations and individuals that please approach as soon as possible so that effective remedies can be granted under Article 32. So, Article 32 has grown over a period of time, both in terms of private individuals seeking the intervention of the court, like in the case of Menaka Gandhi versus Union of India, or maybe in terms of the public interest litigation that has been championed by the Supreme Court from time to time. So there are two ways in which the writ under Article 32 can be granted. One thing that probably has to be said over here is that the Supreme Court has been a court that has not only given orders and directions and writs, it has also looked at managing executive action. So there is something called continuing mandamus. Now, if you see in a very famous case, this is called the Forest Case of India. It is called the T.N. Godavarman versus Union of India. T.N. Godavarman Tirumalapada versus Union of India. This was a petition filed in the year 1996. That was the first time it was decided. And the Supreme Court was kind of surprised that the forests are not being managed or conserved effectively for the better right of a good environment or a healthy environment. And hence, the Supreme Court took upon itself the business, I must say, of managing India's forest. So, over the period of, say, more than 15 or 20 years, the continuing mandamus even goes as of now in the Supreme Court. Very recently, just last year, we had a case decided under the T.N. Godavarman. So, all these years, it was a continuing mandamus. It was the order of the court saying that, look, in case there has to be any executive decision taken in forests in India, you must approach to the court. So the officers in the government had no power to decide about how and what matters to be taken inside forest area. They could only do that after the permission of the court. And that's why this T.N. Godavarman case is a case of what we call as continuing mandamus, where the courts would want to supervise, monitor, and implement its orders. And hence, what the court did in the T.N. Godavarman case was it appointed what is known as the Centrally Empowered Committee. And this committee would take a call and they would report to the Supreme Court as the case may be. Now, Article 32 is a fundamental right to constitutional remedies. Having said this, please note the way in which judicial review happens in India and why there is so much of respect for the judiciary, you will notice is because the judiciary has what is known as the power of contempt. If any individual willfully, does not comply with the orders of the court, be it the High Court and the Supreme Court, then for that kind of a non-compliance, intentional, willful, the court can actually take action against that individual, be it an executive officer or be it any other private citizen. The courts can actually take action for contempt of court. And please note, there is two kinds of contempt. One is called the civil contempt, where you may be asked to pay a fine. And there is criminal contempt, where you may be asked to go to the jail for not following the directions and the orders of the court. So, I think the courts usually may not use criminal contempt, but they may impose a very exemplary cost in case you do not comply with the orders of the court. So, in that context, you will notice that the power of the judiciary in India is very, very important, and that's where the courts are able to issue their writs. And through this, I think it should be very convincingly said that the Supreme Court and the judiciary, Supreme Court in particular and judiciary in general, has been able to eradicate a lot of evils in our society. Yes. And I think if one scrutinizes the directions of the court in the last 30 years, especially post emergency, you will notice that the prerogative writs that have been issued, and please note, this has been, I must say, the writs have been the fountain of justice. And though, to a larger extent, the idea of the writs may come from common law, it may come from England. I think they have been very, very clearly something that has laid the foundation of justice in this country. I think to a larger extent, um, it's been very clear that the writs are, substantially checking public administration. They almost have a permanent character in how they have been issued. And I think this has been the really, the jewel in the crown, that is the jewel in the constitution. And the legality of so many, actions of the executive and the legality of so many laws are also something that the courts have done over a period of time. Okay. Now, just a couple of more points before we go to Article 226. Uh, One thing is that Article 32 can be invoked by both individual citizens as well as by corporate citizens. Now, what do I mean by this? I mean that sometimes industries may feel that their right is being violated. A company may feel their right is violated. A society may feel. The press, for example, may feel that their rights are being violated under the Constitution, and they are also entitled to exercise the power to go and approach to the Supreme Court. Okay. Uh, can you go under Article 32 to the Supreme Court when you think that a law is being enacted without jurisdiction? The answer is yes, you can. Okay. Can you go to the Supreme Court if an kind of an action is taken in a malified manner? The answer is yes, you can. Uh, can you go to the Supreme Court seeking in the intervention in case, say, the officers of the government itself, in their employment services, feel that there is an arbitrary action? So it's not only for citizens. I'm talking of government employees. I'm talking of public servants. If they feel that within their organization and department there is no fairness, there is no equity, there is no justice, can they also seek the intervention of the court under Article 32? Again, the answer is also in a positive. Has Article 32 being utilized for election matters by even, say, political parties, for example, or by citizens, or by the Election Commission of India? Again, you notice that the answer is an affirmative. Right? So, a lot of institutions that are constitutional bodies, like the Election Commission being one, have approached the court directly and have seen their intervention for any kind of wrong that they feel should be brought to the attention of the court. And they feel that yes, this is where there needs to be a judicial intervention on a national level so that the constitutional principles can be enhanced and better protected. Okay. Some of the legislations, friends, which affect, say, rights, can also be challenged under Article 32. For example, the Supreme Court has been approached in the triple talaq case, either in the original jurisdiction or in the appellate jurisdiction. Uh, so, yeah, I think this is a very long list of matters that the Supreme Court has intervened. And they have given relief to workers in terms of compensation. They have given relief to sex workers. They have given relief in service matters, and so on and so forth. So, a lot of these, matters like they may be, say, rights emanating from contracts. They may be rights, customary rights. They may be rights following from a subordinate legislation. or a right based on a case law. All of these have been used uh, for the intervention of the court. Now, just before we go to Article 226, one should look at a very important word of caution here, and that is the Supreme Court has time and again imposed cost if the writ power of the court has been misused for frivolous petitions or for speculative matters. So I think the court then dismisses such kind of petitions because the time of the Supreme Court is very, very precious. And going to the court for all small matters or frivolous matters, say trying to look at putting a ban on some film on some speculative character that it may hurt religious sentiments. So you can't, Supreme Court is supreme in that context. The time is also supremely important. So in those kinds of situations, I think the court then will dismiss it with a warning, impose a cost either on the petitioner or on the lawyer who should have checked whether this is a matter admissible under the writ power or not. So that is the word of caution against misuse of the writ jurisdiction.